Kasi I worked 15 years paying for my mother's house. When I finished, she put my sister as the heir and told me, "You had the privilege of serving me." Tamiralik Hamad, as the manila envelope that the notary's office had just handed me weighed so heavily in my trembling hands that I needed to sit immediately on the worn wooden bench in the institutional hallway before my weir sai. Legs gave out completely under the devastating psychological weight of what I had just discovered through technical words printed on an official document that instantly transformed 15 entire years of brutal financial sacrifices into a cruel farce orchestrated by the only person who should have protected me unconditionally in this world. Taichisemna, the final deed of the residential property, for which I had religiously paid every penny during a decade and a half of exhausting work, including consecutive night shifts as a nurse at 3 different hospitals, simultaneously listed as the sole legal heir, not my full name that I expected to see officially registered acknowledging my monumental efforts, but rather my younger sister Patricia's name, followed by all the legal qualifications that established unequivocally her exclusive ownership over the 3-bedroom property located in a quiet residential neighborhood where our mother Sandra had been living comfortably for over 20 years, enjoying housing stability that only existed because I had literally sacrificed everything during the best years of my adult life. Aisha Sayore, I had literally sacrificed everything to ensure she would never experience financial insecurity related to precarious housing or eviction threats that haunt millions of American families living perpetually on the edge of economic survival. My 43 years of existence carefully built on foundations of unwavering family responsibility. Honest work executed with exemplary professional dedication, recognized by supervisors and colleagues who witnessed countless times my exceptional commitment to patients needing urgent medical care, and especially on the comforting certainty that I was building a secure future for my elderly mother, who deserved to age with dignity after decades raising 2 daughters alone. Anda iterisar, my mother deserved to age with dignity after decades raising 2 daughters alone after our father abandoned the family when I was only 12 years old, leaving Sandra without substantial financial resources beyond a modest salary as an administrative secretary in a small commercial office. Completely collapsed when I read for the 5th consecutive time that official document certified by a notary that transformed my heroic sacrifices into a cruel joke whose devastating ending I could never have anticipated even in my worst nightmares about family ingratitude. The physical sensation was exactly like having the solid floor of the institutional hallway literally disappearing from under my feet, leaving me falling in free fall through an emotional abyss that seemed to have no visible bottom where I could land with any hope of recovering minimally functional psychological balance that would allow me to rationally process the impossible meaning of that maternal betrayal. Executed with calculating coldness that revealed dimensions of cruelty I never imagined existed within the woman who gave me life biologically, but apparently never developed the emotional capacity to genuinely love me as a daughter, deserving of recognition and gratitude. Never developed the emotional capacity to genuinely love me as a daughter, deserving of recognition and gratitude for everything I voluntarily sacrificed in her name. Throughout my entire adult life, meticulously organized around family obligations that I assumed without questioning since adolescence, when I realized Sandra was desperately struggling to pay basic monthly bills, with insufficient salary that barely covered adequate food and essential expenses like water, electricity, and public transportation necessary for her to arrive daily at work, crossing a huge city where crowded buses represented brutal daily reality for millions of American workers. I maintained an exhausting routine that began at 5 in the morning when I woke up in the tiny one-bedroom apartment rented in a distant neighborhood where I had lived alone since I turned 28, and finally managed to save the minimum deposit required by distrustful landlords, and frequently ended after midnight when I returned exhausted from consecutive hospital shifts that completely drained my physical and emotional energies, but paid salaries that allowed not only my modest survival, but mainly sent substantial monthly amounts to Sandra's bank account specifically designated to cover installment payments. Heir the installment payments of the mortgage financing that she had signed 15 years earlier, when she finally got bank approval to buy a small but decent house that represented her lifelong dream of owning property where she could age safely, without depending on rents that consumed a disproportionately high percentage of limited monthly income. I had never questioned that financial arrangement that consumed approximately 60% of my monthly salary as a nurse working night shifts that paid necessary premiums to cover both my basic personal expenses and mainly those regular transfers to Sandra. Sandra always received those transfers with apparent gratitude, accompanied by emotional hugs and verbal declarations about how much she appreciated my sacrifices, ensuring she could keep her own house, instead of returning to the chronic instability of living in rented properties where landlords could arbitrarily cancel contracts, leaving entire families homeless with insufficient minimum notice to find adequate housing alternatives. Patricia, my sister 5 years younger, who was always visibly Sandra's favorite, through differential treatment that included special permissions, frequent gifts bought with scarce financial resources that should have been reserved for basic needs, and especially complete absence of expectations about financial contributions to collective family support. Never transferred a single penny to help with payments for that house that I now discovered was registered exclusively in her name, as if my 15 entire years of monumental sacrifices simply didn't exist in official reality, documented through notarial records that legally determine who owns rights over disputed properties in courts, when families inevitably fragment through conflicts over inheritances and recognition of historical financial contributions. Ka are the most disturbing memory that repeatedly emerged from my traumatized consciousness while I remained sitting on that institutional bench holding that devastating deed was of a specific conversation I had with Sandra exactly 3 months earlier when I finally made the last payment of the mortgage financing after a decade and a half of uninterrupted monthly transfers that totaled an astronomical value sufficient to have bought my own modest apartment, instead of financing housing for someone else who now revealed she had no intention whatsoever of officially recognizing my financial contributions. I my financial contributions that literally represented blood, sweat, and tears shed through years of exhausting work that progressively destroyed my physical health through consecutive night shifts that completely dysregulated natural circadian rhythms, causing chronic insomnia, persistent gastrointestinal problems, and especially accumulated emotional exhaustion that doctors repeatedly warned could result in a nervous breakdown if I didn't reduce the brutal workload I maintained voluntarily only to ensure Sandra lived comfortably. In that apparently casual conversation held in the modestly furnished living room of the house I had paid for entirely, I casually mentioned that I was finally relieved to complete the payments and that maybe I could start saving for down payment on my own apartment, instead of continuing to waste money on monthly rent for a tiny property inadequate for a 43-year-old woman who should be established in her own residence, reflecting decades of hard work and responsible financial planning. Sandra had reacted to that innocent comment with disturbing prolonged silence, followed by an enigmatic smile that at the time I interpreted as maternal pride about my growing financial maturity and ability to finally prioritize my own housing needs after years sacrificing everything to ensure her security, but that I now realized retrospectively was an expression of cruel satisfaction about having perfectly executed a manipulative plan elaborated during a decade and a half, where she systematically exploited me while building real estate equity that would exclusively benefit Patricia. Instead of minimally recognizing the person who actually financed the acquisition of that property through sacrifices that Sandra directly witnessed but apparently never genuinely appreciated, beyond the financial convenience that my monthly transfers provided, allowing her to live comfortably without needing to work overtime or make significant personal sacrifices that characterized my existence during the best years of my adult life. Her following words in that conversation 3 months earlier now echoed in my traumatized memory, with completely sinister meaning that I had been too naive to detect at the time. She had said with a soft but firm voice that I shouldn't worry about questions related to property ownership because she had organized everything legally ensuring I would be treated fairly, an ambiguous phrase that I had generously interpreted as confirmation that my name would be included on the deed recognizing my substantial financial contributions, but that I now understood had been a deliberate lie intended to keep me transferring money until the last payment was completed, before revealing that Patricia would be the sole legal beneficiary of property I had entirely financed during 15 years of exhausting work. 5 years that exhausting work consumed my youth and destroyed prospects of building a satisfying personal life, including serious romantic relationships that inevitably failed because potential partners didn't understand nor accept my inflexible commitment to family financial obligations that left minimum resources for recreational activities or emotional investments in relationships that demanded quality time and dedicated attention. Marcos, my 45-year-old ex-fiancé with whom I had maintained a promising relationship for 3 years before we ended bitterly 2 years ago, had terminated our engagement specifically because he couldn't accept that I continued prioritizing substantial monthly transfers to Sandra. Instead of saving for the wedding, he was meticulously planning, including a modest ceremony followed by an international honeymoon, that represented our shared dream of experiencing together a romantic trip to a tourist destination we had never visited previously. He repeatedly argued with growing frustration that adult and fully capable Patricia should assume responsibility for half of the financial contributions to Sandra, instead of leaving me to carry the burden alone while she lived comfortably working part-time at a sophisticated boutique selling expensive clothes to wealthy clients and spending her modest salary entirely on personal luxuries, like weekly manicures, monthly aesthetic treatments at expensive salons, and especially frequent trips to popular beach resorts where she posted photographs on social networks showing a carefree lifestyle completely indirectly subsidized by my financial sacrifices that ensured Sandra never needed to ask Patricia for financial help, thereby preserving harmonious relationship between mother and favorite daughter, while I was systematically exploited through implicit expectations about obligations of the responsible older daughter, who never complained nor questioned profoundly unfair family arrangements that disproportionately benefited people who contributed minimally, while cruelly penalizing those who voluntarily sacrificed everything. Through a distorted sense of filial duty that Sandra had deliberately cultivated through decades of subtle psychological conditioning, the devastating decision about what to do in the face of that disturbing discovery became an existential question that kept me awake during the following 4 nights, obsessively alternating between different possible courses of action while observing the ceiling of the tiny apartment. Through the suffocating darkness of sleepless early mornings, where my mind frantically processed the complete implications of that maternal betrayal that retrospectively transformed 15 entire years of heroic sacrifices into cruel exploitation. Toward cruel exploitation executed by a person who should have loved me unconditionally, but apparently only saw me as a convenient source of financial resources that could be indefinitely extracted through emotional manipulation, disguised as maternal gratitude. The most obvious option would be simply to accept that devastating injustice and move on with my life, trying to rebuild personal financial stability through rigorous savings during coming years, hoping eventually to accumulate sufficient resources for down payment on my own apartment. But that passive alternative would essentially mean validating Sandra's exploitative behavior. And mainly allowing Patricia to permanently benefit from real estate equity that she absolutely didn't finance nor deserved to receive as exclusive inheritance simply because she was the spoiled favorite daughter who never significantly contributed to collective family welfare during her entire privileged adult life. Another possibility would be to directly confront Sandra, demanding explanations about why she had betrayed me so cruelly after I had literally sacrificed everything during the best years of my life to ensure her housing security. But that alternative brought the terrible risk of being received with manipulative denial. Or worse yet, with explicit confirmation that she always only saw me as a convenient financial instrument, instead of a daughter deserving of genuine maternal love and recognition for the monumental sacrifices I made voluntarily, believing naively that I was building a family relationship based on mutual gratitude and reciprocal support that would characterize our future years when she aged, needing care, that I presumed to provide lovingly as a natural extension of the commitment I demonstrated through decades of uninterrupted financial support. The third option, which gradually imposed itself as the only really viable one, despite all the emotional costs involved, was to seek legal justice through a judicial process against Sandra and Patricia, demanding official recognition of my substantial financial contributions, and especially equitable division of the real estate property that I had effectively bought through 15 years of monthly payments that totaled the total value of the property, including accumulated interest, that banks mercilessly charge mortgage loan borrowers during decades of real estate financing, that enriches financial institutions while draining resources from working families, desperately struggling to achieve the basic dream of owning their own housing. This judicial alternative would inevitably mean permanently destroying any remaining vestige of family relationship with Sandra and Patricia, transforming a dynamic that was already irreparably damaged by the discovered betrayal into a public legal war that would be judged by courts through objective legal principles instead of subjective family loyalties or emotional manipulations that Sandra had employed so effectively for decades to keep me financing her comfortable lifestyle, while I lived precariously in an inadequate tiny apartment, reflecting the grotesque disproportion between sacrifices I made and benefits I received in return. Through a maternal relationship that I now realized had been fundamentally transactional instead of genuinely loving, as I had naively believed throughout my entire adult life. Dedicated to serving Sandra's needs prioritarily over my own basic needs for housing security and financial stability that every working person deserves to achieve through decades of honest efforts and responsible planning. The growing sensation was that Sandra had deliberately built an elaborate financial trap during 15 entire years, systematically exploiting my sense of filial responsibility, and especially my naivety about the transactional nature of our relationship. Akarayin Nagchu that she always clearly understood while I remained deluded, believing I was building a solid foundation of maternal gratitude that would be officially recognized when the appropriate moment arrived. To formalize questions related to property ownership of the property I had entirely financed, sacrificing prospects of building my own housing stability during the most productive years of my professional life. On the cold Monday morning following the discovery of that devastating deed, I put on my clean and ironed hospital uniform, trying to project an image of professional competence that grotesquely contrasted with the internal emotional chaos that threatened to completely consume me. I drove my old compact car to the law office located in a busy commercial district where Dr. Fernando maintained a specialized practice in family law and estate disputes involving contested inheritances and especially recognition of historical financial contributions that families frequently deny when the moment arrives to divide properties among heirs who contributed unequally to the acquisition of disputed estates. The modestly furnished waiting room was empty that morning, allowing me to be quickly attended by an efficient secretary who led me through a narrow corridor to a private office where Dr. Fernando awaited me sitting behind an organized desk, filled with stacked legal cases demonstrating substantial volume of similar cases involving families destroyed by disputes over recognition of financial contributions and equitable division of properties acquired through collective efforts that are frequently unjustly appropriated by individuals who contributed minimally but manipulated legal situations to benefit disproportionately. Dr. Fernando was a brown man of approximately 51 years wearing a conservative gray suit that transmitted professional authority mixed with human accessibility necessary to deal with clients traumatized by family betrayals. His graying hair combed to the side conferred an air of maturity and experience accumulated through decades representing people in emotionally devastating legal conflicts, and especially his brown eyes demonstrated that particular combination of genuine empathy and legal realism that characterizes exceptionally effective lawyers in cases involving family disputes, where intense emotions frequently obscure objective facts that courts need to evaluate through documentary evidence and verifiable testimonies. When I sat in the leather chair in front of his desk, I breathed deeply, trying to control the tremors shaking my hands while I carefully extracted from my purse the deed that had completely destroyed my understanding about the maternal relationship I believed I was building through 15 years of monumental financial sacrifices. And I began explaining with a voice choked by conflicting emotions the absolutely devastating situation that had led me to that legal office on a Monday that could determine whether I would spend coming years legally fighting for recognition of my contributions or simply accept that cruel injustice as a painful lesson about the transactional nature of family relationships that I had been too naive to adequately understand throughout my entire adult life, dedicated to serving others' needs prioritarily over my own basic needs for security and stability that every working person deserves to achieve. What Dr. Fernando revealed to me during that initial consultation would completely transform my understanding about legal complexities involving recognition of financial contributions in properties registered exclusively in names of third parties who benefit from payments made by other people who naively believe they are building shared equity that will be officially recognized when the appropriate moment arrives to formalize property questions through adequate legal documentation. His first words were simultaneously comforting and disturbing, revealing that my situation was not unique, but rather a common pattern he regularly encountered representing clients who had been systematically exploited. By manipulative family members who deliberately built ambiguous financial arrangements allowing them to extract substantial resources from dedicated relatives while maintaining exclusive legal control over properties acquired through those unrecognized financial contributions officially. Ms. Marina, I perfectly understand the emotional devastation you're experiencing upon discovering that 15 entire years of monumental financial sacrifices did not result in legal recognition of your contributions to the acquisition of the real estate property that your mother registered exclusively in your sister's name. He began with a controlled but compassionate voice that demonstrated substantial experience dealing with clients traumatized by similar family betrayals that destroyed emotional foundations of relationships that seemed solid until moments of devastating revelation completely transformed understandings about the nature of those interpersonal bonds. Unfortunately, situations like yours are extremely common in American families, where informal financial arrangements based on mutual trust and family loyalty are frequently exploited by manipulative individuals who consciously or unconsciously take advantage of the generosity of dedicated relatives without real intention of officially recognizing those financial contributions when the moment arrives to formalize property questions through legal documentation that unequivocally establishes who possesses rights over disputed estates. Dr. Fernando explained, revealing the systemic dimension of the problem that went far beyond my individual personal experience. His words confirmed that my naivety about the nature of the financial arrangement with Sandra was not a unique personal defect, but rather a common vulnerability that manipulative families systematically exploit through centuries of informal practices where substantial financial contributions are extracted from dedicated relatives through implicit promises about future recognition that never materialize when decisive moments arrive to legally formalize property questions that should reflect real historical contributions instead of arbitrary favoritism or emotional manipulations. Water that characterize dysfunctional family dynamics where some people are systematically exploited while others benefit disproportionately without adequately contributing to the acquisition of theoretically shared but unjustly appropriated estates in practice through legal manipulations that courts frequently validate when explicit documentation is lacking, proving informal financial arrangements based on family trust that should be sacred but is frequently cruelly violated by people who prioritize material gains over relational integrity and genuine gratitude for monumental sacrifices they directly witnessed during years of close coexistence, revealing the complete extent of those heroic efforts. A doctor. Fernando leaned back slightly in his leather chair while observing my devastated expression with that particular combination of professional empathy and genuine concern that characterized lawyers truly committed to the well-being of clients facing legally complex situations that threatened to destroy emotional foundations of their existences, carefully built during decades of honest work and family dedication, that now seem to have been cruelly wasted on fundamentally transactional relationships disguised as genuine maternal bonds. His following words would reveal additional dimensions of legal complexity involving recognition of historical financial contributions in properties registered exclusively in names. Item Yisfasher of third parties who systematically benefited from payments made by dedicated relatives who naively believed they were building shared estates that would be officially recognized when the appropriate moment arrived to formalize property questions through adequate legal documentation that would protect rights of all contributors involved in the acquisition of those disputed properties. The first critical question we need to address, Ms. Marina, is to documentarily establish the exact extent and specific nature of your financial contributions during those 15 years of uninterrupted mortgage financing payments that your mother Sandra originally signed, but that you effectively financed through monthly transfers that consumed a substantial portion of your salary as a nurse working exhausting shifts. Doctor, Fernando explained with technical precision while opening an organized folder full of legal forms and handwritten notes, demonstrating meticulous preparation for that consultation that he clearly understood to be crucial for determining viability of an eventual judicial process against a family member who had systematically exploited trust and dedication of her daughter during a decade and a half. Do you possess complete banking documentation proving all those monthly transfers made during the last 15 years, including detailed statements showing specific amounts, precise dates, and especially transaction descriptions, explicitly identifying that those payments were specifically destined for coverage of the mortgage financing installments of the property registered in your mother's name? Doctor. Fernando's apparently simple question immediately awakened growing anxiety, because although I had maintained reasonably organized control of my personal finances during those 15 years of monumental sacrifices, I honestly hadn't systematically preserved all the banking receipts of each monthly transfer made to Sandra specifically because I never imagined I would need to judicially prove something I naively believed would be naturally recognized through maternal gratitude and especially through legal documentation that I presumed Sandra was adequately organizing to reflect my substantial contributions when the appropriate moment arrived to formalize property questions. I have banking statements from the last 7 years stored digitally because my bank offers online access to transaction history for that period. But unfortunately, I didn't keep physical receipts from the first 8 years of payments because I was living in a tiny apartment with limited space for document storage, and especially because I trusted that my mother was maintaining adequate records of my financial contributions that she received monthly during that entire decade and a half. I explained with growing frustration about my naivety regarding the importance of maintaining complete documentation of informal family financial arrangements. Dr. Fernando nodded understandingly while making detailed notes on a notepad strategically positioned on his organized desk. demonstrating through reassuring body language that my situation was not hopelessly compromised by the absence of complete documentation from the first years of financial contributions. The good news, Ms. Marina, is that even without complete physical receipts of all transfers made during the entire 15 years, we can still build a legally solid case demonstrating a consistent pattern of substantial financial contributions through available documentation from the last 7 years combined with testimonies from people who knew about the financial arrangement between you and your mother. He explained, revealing a legal strategy that partially alleviated my anxiety about consequences of incomplete documentation. Banks are required by federal regulations to maintain complete records of all financial transactions for a minimum period of 10 years. So we can formally request through appropriate legal procedures that your banking institution provide detailed statements covering the complete period of 15 years of transfers, which would unequivocally establish the systematic pattern of monthly payments you consistently made specifically destined for coverage of mortgage financing installments. And the revelation that complete banking records could be recovered through formal requests brought substantial relief mixed with renewed hope that perhaps there existed a viable path to seek legal recognition of my monumental financial contributions that had been systematically denied through the devastating deed that exclusively listed Patricia as heir of the property I had effectively bought through 15 years of brutal sacrifices. Dr. Fernando continued explaining legal complexities involving cases of unjust family enrichment, where one person disproportionately benefits from financial contributions made by a close relative without adequately recognizing those contributions through appropriate legal documentation that would protect the real contributor's rights. The fundamental legal concept we will apply in your case, Ms. Marina, is known as unjust enrichment or enrichment without cause, which occurs when a person obtains patrimonial advantage at the expense of another without adequate legal justification that legitimizes that transfer of resources. He elaborated with academic precision characteristic of lawyers who profoundly master theoretical aspects of law beyond practical litigation skills. In the specific context of your family situation, we can convincingly argue that your mother, Sandra, and especially your sister, Patricia, unjustly enriched themselves at your expense. By exclusively appropriating real estate property whose acquisition was substantially or entirely financed through your monthly contributions made systematically during 15 consecutive years. Dr. Fernando continued, revealing the conceptual structure that would ground an eventual judicial process against Sandra and Patricia, demanding recognition of my contributions and especially equitable division of the property, reflecting real financial investments made by each party involved in the acquisition of that disputed property. American law explicitly protects against unjust enrichment through various legal mechanisms that allow people harmed by improper appropriations of financial resources to seek adequate restitution through courts. That will objectively evaluate documentary and testimonial evidence to determine who really financed the acquisition of disputed properties, and especially how those estates should be equitably divided among all parties who legitimately contributed to their acquisitions. Dr. Fernando's warnings about emotional challenges of family litigation were disturbing but necessary, because I needed to make an informed decision about proceeding with a legal process, fully understanding psychological costs involved beyond substantial financial costs that would inevitably accompany years of judicial battles against a family member who had betrayed me so cruelly. Third, there always exists a real possibility that even after years of expensive and emotionally draining litigation, courts might decide that your financial contributions were insufficient to guarantee shared ownership of the residence, especially if your mother convincingly argues that you contributed voluntarily as a dedicated daughter, supporting her housing needs without formal expectation of receiving proprietary recognition in exchange for those monthly payments. Dr. Fernando explained, revealing substantial legal risk I needed to carefully consider before investing limited financial and emotional resources in a judicial process whose outcome couldn't be guaranteed in advance, even with apparently solid legal grounding. The arguments that Dr. Fernando anticipated that Sandra and Patricia's lawyers would present were legally solid and disturbingly persuasive, revealing that my perception about the obvious justice of my claim might not be shared by judges evaluating the case through technical legal principles instead of intuitive sense of equity, that led me to believe I should be recognized as legitimate owner of property I had entirely financed. Having said all that about substantial challenges we'll face, I must also emphasize that you possess a legally viable case based on the concept of unjust enrichment that American courts consistently recognize as legitimate grounds for restitution of improperly transferred resources. Dr. Fernando continued balancing realistic warnings with professional encouragement about viability of seeking legal recognition of my contributions. The banking documentation from the last 7 years will establish an unequivocal pattern of substantial monthly transfers consistently made to your mother, and we can complement that documentary evidence with testimonies from work colleagues, ex-fiancé, and other people who knew about the exploitative financial arrangement between you and Sandra, confirming that you literally sacrificed everything, during 15 years specifically, to ensure she could maintain her own house. Additionally, the fact that you lived during all those 15 years in a tiny rented apartment, instead of buying your own property, reinforces the argument that your monthly transfers weren't voluntary gifts, but rather financing payments specifically destined to acquire property that you reasonably expected would be recognized as shared estate or your exclusive property, considering the magnitude of financial contributions you made sacrificing prospects of building your own housing stability. Dr. Fernando elaborated, revealing a narrative strategy that would transform facts of my life into persuasive legal arguments that courts could favorably evaluate when determining equitable division of the disputed property. The central question that courts will need to decide is whether your monthly transfers during 15 years constituted voluntary gifts made by a dedicated daughter supporting maternal housing needs without expectation of proprietary recognition, or whether those transfers represented financing payments that created legitimate proprietary rights over property acquired through those substantial financial contributions you made, literally sacrificing everything during the best years of your adult life. Dr. Fernando's formulation about the central question of the case revealed that the judicial battle would fundamentally be about interpretation of the nature of my monthly transfers, and especially about whether I had reasonable expectation of proprietary recognition. The time I made those financial contributions during a decade and a half. To strengthen our argument that you had legitimate expectation of proprietary recognition, instead of simply making voluntary gifts, we'll need to demonstrate through testimonies and circumstantial evidence that you and your mother had an implicit or explicit understanding that your financial contributions would result in legal recognition of your rights over the property. He explained, revealing the critical importance of reconstructing conversations and understandings I had maintained with Sandra during those 15 years of financial sacrifices. Do you remember specific conversations with your mother where she explicitly acknowledged your financial contributions, and especially where she made promises or statements suggesting you would be recognized as legitimate owner or co-owner of the residence, considering the magnitude of payments you were making monthly during a decade and a half? Dr. Fernando's question awakened painful memories of conversations I had had with Sandra during those 15 years where she frequently expressed verbal gratitude for my financial contributions, but always in an ambiguous manner that never clearly specified whether that gratitude would translate into formal legal recognition through appropriate documentation conferring proprietary rights over the property I was effectively buying. There was a specific conversation approximately 3 months ago, when I made the last financing payment, where I casually mentioned I was relieved to finally complete the payments and that maybe I could start saving for my own apartment. And my mother responded saying I shouldn't worry about property questions because she had organized everything legally, ensuring I would be treated fairly. I reported reconstructing that disturbing memory that at the time I generously interpreted as confirmation of future recognition, but retrospectively realized had been a deliberate lie intended to keep me transferring money until the last payment was completed. Arshas odds. That conversation you just described is extremely important because it establishes that your mother explicitly acknowledged your concerns about property ownership, and especially made a specific statement promising you would be treated fairly regarding proprietary questions, which creates a legal basis for the argument that you had reasonable and legitimately induced expectation of proprietary recognition, instead of simply making voluntary gifts without any expectation of return. Dr. Fernando explained with growing enthusiasm, revealing that that specific memory could be crucial to strengthening the judicial case against Sandra. Verbal statements made by one of the parties acknowledging obligations or promises related to financial arrangements are legally binding even if they weren't formalized through written documentation, especially when those statements induce the other party to continue making substantial financial contributions based on trust that promises would be adequately fulfilled when the appropriate moment arrived to formalize proprietary questions. Dr. Fernando's words transformed that apparently casual conversation with Sandra into potentially decisive legal evidence that could substantially influence how courts would interpret the nature of my financial contributions, and especially whether I had legitimate rights over property I had financed during a decade and a half. Besides that specific conversation 3 months ago, Do you remember other occasions during the 15 years when your mother made similar statements, acknowledging your contributions, or suggesting you would be proprietarily recognized considering the magnitude of payments you were making? Doctor. Fernando asked, encouraging me to systematically reconstruct the complete history of communications with Sandra that could establish a pattern of promises or acknowledgments creating legitimate expectations about future proprietary rights. I tried to recover fragmented memories of conversations maintained with Sandra during those 15 years, while I made monthly transfers that consumed a disproportionate portion of my salary as a nurse working exhausting night shifts. But honestly, most of those interactions were routine and not particularly memorable, because I naively assumed the financial arrangement was mutually understood, and that formal recognition would happen naturally when the appropriate moment arrived without need for explicit conversations about legal formalization of proprietary expectations that I considered obvious given the magnitude of my financial contributions. There were periodic occasions during those 15 years when Sandra casually mentioned she was grateful for my contributions, ensuring she could keep her own house instead of returning to the instability of rented properties. But those statements were always expressed generally without specifications about how that gratitude would translate into formal legal recognition. I explained with frustration about my naivety in not insisting on explicit conversations, formalizing proprietary expectations through adequate legal documentation, protecting my interests from the beginning of the financial arrangement. Dr. Fernando nodded understandingly while making detailed notes revealing that even general statements of gratitude could be interpreted as implicit acknowledgments of future obligations related to formalization of proprietary rights considering the context of substantial financial contributions made systematically during a decade and a half. The general pattern of your mother's behavior during those 15 years, consistently accepting your monthly transfers, expressing verbal gratitude for contributions, and especially never explicitly communicating that you would not have proprietary rights over property being financed through your payments, establishes basis for legal argument that you developed legitimate and reasonably induced expectation of future proprietary recognition. Second, the fact that you sacrificed your own housing stability living in an inadequate tiny apartment during all those 15 years instead of saving to buy your own property demonstrates that your monthly transfers weren't gifts made from excess resources, but rather investments that consumed resources you should have used to build your own housing security. Doctor. Fernando continued systematically building a robust legal argument that courts could favorably evaluate when determining the nature of my financial contributions. Third, your mother never contributed proportionally to the property acquisition, despite having financial capacity to do so through salary as an administrative secretary. In which suggests the financial arrangement wasn't voluntary filial support, but rather an implicit division of responsibilities where you entirely assumed financing, while she enjoyed benefits of living in property being acquired through your sacrifices without adequately contributing to acquisition costs. The arguments Dr. Fernando was systematically articulating were legally solid and persuasive, transforming facts of my situation into a coherent narrative that courts could interpret favorably when evaluating whether I had legitimate rights over the disputed property. Fourth, the specific moment when your mother formalized transfer of the property exclusively to your sister, exactly after the last financing payment was completed, strongly suggests there was deliberate intention to exploit your financial contributions until the last possible moment before revealing you would not be proprietarily recognized, despite having entirely financed the property's acquisition. Dr. Fernando elaborated, revealing a particularly sinister aspect of Sandra's behavior that courts could interpret as evidence of bad faith instead of legitimate exercise of proprietary rights over property registered in her name. This strategic timing demonstrates that your mother clearly understood during all those 15 years that you expected future proprietary recognition, and she deliberately avoided formalizing transfer to Patricia until the moment when the last payment was completed, ensuring you would continue making financial contributions until the end of financing, based on expectations she knew would be frustrated as soon as the transfer was finalized. Dr. Fernando's characterization of Sandra's behavior as deliberately deceptive instead of simply exercise of legitimate rights was comforting because it validated my perception about having been systematically exploited through a financial arrangement built on implicit promises never intended to be adequately fulfilled. Finally, the complete absence of financial contributions from your sister Patricia during those 15 years, combined with the fact she was designated exclusive heir, strongly suggests there was arbitrary maternal favoritism instead of equitable distribution of estate based on each daughter's real contributions to the disputed property's acquisition. Dr. Fernando concluded, presenting the fifth fundamental argument, establishing a systematic pattern of financial exploitation instead of legitimate family arrangement based on mutual support and proportional recognition of individual contributions. His explanations were progressively transforming my painful personal experience into a structured legal case that could be convincingly presented before courts, objectively evaluating available evidence about the nature of my financial contributions, and especially about whether those contributions created legitimate proprietary rights that Sandra and Patricia were deliberately violating through the exclusive transfer registered in official notarial documentation. Based on all these combined factors, exceptional magnitude of your contributions, sacrifice of your own housing stability, absence of proportional contributions from your mother, strategic timing of transfer to Patricia, and especially arbitrary favoritism that exclusively benefited your sister who never financially contributed, we can build an extremely persuasive legal argument that you possess legitimate proprietary rights over a substantial portion or even the entirety of the real estate property that was acquired through your monthly payments during a decade and a half of monumental sacrifices. Dr. Fernando summarized with growing professional confidence that began convincing me that perhaps there really existed a viable possibility of seeking justice through the legal system, despite all the emotional and financial challenges involved in prolonged litigation against family members who had betrayed me, so cruelly exploiting my filial dedication. My Turkishnam, and especially my naivety about the transactional nature of the relationship that Sandra always clearly understood while maintaining comforting illusions that kept me consistently transferring money. The next crucial step would be to systematically gather all available evidence that will ground our initial petition when we decide to file a judicial process against your mother and your sister, Dr. Fernando explained, transitioning from theoretical analysis to practical planning of concrete actions necessary to transform abstract legal arguments into a formal legal case officially presented before competent courts. We'll need to formally request complete banking statements covering the entire period of 15 years of monthly transfers. Identify and prepare witnesses who can confirm knowledge of the financial arrangement between you and Sandra. Compile documentation demonstrating your precarious housing situation during that period that grotesquely contrasts with the comfort your mother enjoyed in the property financed through your sacrifices. And especially document precise chronology of events culminating in the exclusive transfer to Patricia, immediately after completion of the last mortgage financing payment. The list of practical tasks Dr. Fernando systematically enumerated was simultaneously intimidating by the magnitude of work involved and comforting because it demonstrated there existed a structured path to transform my justified emotional indignation into concrete legal action that courts could evaluate through established procedures, designed to resolve complex estate disputes involving families fragmented by conflicts over recognition of historical financial contributions. Additionally, it would be extremely useful if you could reconstruct a detailed chronology of significant conversations maintained with your mother during those 15 years, where she acknowledged your contributions or made implicit or explicit promises about future proprietary recognition. He continued, revealing the importance of systematically documenting qualitative aspects of the relationship that would complement quantitative evidence of financial transfers, establishing emotional and relational context that would help courts understand the nature of the arrangement between me and Sandra. Particularly important will be documenting that specific conversation 3 months ago when you mentioned intention to save for your own apartment, and your mother responded promising you would be treated fairly in proprietary questions because she had organized everything legally. Dr. Fernando emphasized, highlighting the probative value of that specific interaction that could be interpreted as explicit recognition of maternal obligations related to formalization of proprietary rights reflecting my substantial contributions. If possible, it would be ideal to identify anyone who might have witnessed that conversation or similar conversations where your mother acknowledged your contributions and made promises about future recognition. Because testimonies from impartial third parties are frequently more persuasive to judges than accounts from the parties themselves involved in disputes where each side naturally presents versions favorable to their particular interests in contested estate litigations. The mention about identifying potential witnesses awakened a specific memory about Gabriella, my 42-year-old work colleague who had occasionally visited me in that tiny apartment during recent years, and especially had directly witnessed several telephone conversations I maintained with Sandra, where we discussed monthly transfers and questions related to the mortgage financing I was entirely covering through my monumental financial sacrifices. I have a close work colleague named Gabriella who visited my apartment several times during recent years and personally witnessed various telephone conversations I had with my mother about monthly transfers, and especially about expectations I maintained about eventual proprietary recognition when financing was completed. I reported realizing Gabriella could provide valuable testimony, confirming the financial arrangement and especially legitimate expectations I developed based on Sandra's implicit promises. Excellent. Your colleague Gabriella's testimony will be extremely valuable because she can independently confirm not only the existence of the financial arrangement, but especially your reasonable expectations about future proprietary recognition based on communications she directly witnessed between you and your mother. Dr. Fernando responded with growing professional enthusiasm. And revealing that testimony could substantially strengthen our case before courts evaluating credibility of conflicting narratives presented by adverse parties in a state litigation. Additionally, it would be useful to identify your ex-fiancé, Marcos, whom you mentioned earlier as someone who intimately knew the financial arrangement with your mother, and especially how that arrangement negatively impacted your prospects of building a satisfying personal life, including the marriage you were planning before the relationship ended due to tensions caused by your family financial obligations that consumed resources that should have been invested in building a shared future as a committed couple. Chakras unto Dr. Fernando's suggestion about including Marcos as a witness was simultaneously sensible from a legal standpoint and emotionally complicated, because although our relationship had ended bitterly 2 years ago, we maintained sufficient occasional contact that I could reasonably request he testify about direct knowledge he possessed about the financial arrangement with Sandra, and especially about how that arrangement had consumed resources and emotional energy that should have been invested in our romantic relationship that eventually failed partially due to tensions created by my inflexible family obligations. Paisos. Marcos would probably be willing to testify because he always argued I was being financially exploited by my mother, and especially by my sister who lived comfortably without adequately contributing to collective family support. I explained, recognizing that despite emotional complications involved in contacting an ex-fiancé, his testimony could be crucial to establishing that people close to me recognized the exploitative nature of the financial arrangement I had naively tolerated during a decade and a half. Perfect, so we have at least 2 potentially strong testimonies from people who intimately knew your situation and can confirm both existence of the financial arrangement, and especially your legitimate expectations about future proprietary recognition based on implicit or explicit promises made by your mother during those 15 years of substantial contributions. Dr. Aguirre. Fernando summarized, making detailed notes about potential witnesses we would need to adequately prepare before the judicial process advanced to the hearing phase, where depositions would be formally collected before judges evaluating credibility of conflicting narratives. Another extremely important aspect we need to address is the question of costs associated with prolonged litigation that will probably extend for several years through multiple judicial instances, including possible appeals. That adverse parties will inevitably present trying to postpone recognition of your legitimate rights over the disputed property. The mention about financial costs of litigation immediately awakened anxiety, because although I was determined to seek legal justice against Sandra and Patricia, my personal finances were extremely limited after 15 years sacrificing 60% of my monthly salary for transfers destined to mortgage financing, that I now discovered would not result in any proprietary recognition unless I legally fought for years, consuming additional financial resources I barely possessed, considering the need to finally save for my own housing stability. After a decade and a half living precariously in an inadequate tiny apartment. Honestly, I'm very worried about litigation costs because my personal finances are extremely limited after years sacrificing most of my salary for monthly transfers destined to property I now discover is registered exclusively in my sister's name. I admitted frankly about financial limitations that could compromise viability of seeking justice through a notoriously expensive legal system, especially in complex cases extending for years. Dr. Fernando nodded understandingly, demonstrating he frequently dealt with clients facing similar dilemmas. It is done where pursuit of legal justice was simultaneously morally necessary and potentially financially infeasible due to substantial costs associated with prolonged litigation. I perfectly understand your concerns about costs, Ms. Marina, and I need to be transparent about the fact that complex estate litigations like yours inevitably involve substantial expenses, including attorney fees, court costs, expert witness fees when necessary, and especially considerable time invested during years of procedural processing through multiple instances. He explained with refreshing honesty that contrasted with lawyers who minimize costs to attract clients who subsequently discovered devastating financial reality of prolonged litigations. However, there are some alternatives that can make litigation financially viable, even for clients with limited resources like you, who literally sacrificed everything during 15 years, leaving you without substantial savings that would normally be necessary to finance complex judicial battles. Dr. Fernando's words about financial alternatives brought partial relief because it suggested perhaps there existed viable paths to seek justice without completely compromising my already precarious financial stability after a decade and a half of monumental sacrifices. First, we can structure contingency fee agreement where you would pay a percentage of the value recovered through favorable judicial sentence. Instead of paying fixed fees upfront during procedural processing, he explained revealing a compensation model that would align the lawyer's interests with the client's interests, because both would benefit proportionally only if litigation resulted in effective recovery of substantial values through judicial recognition of the proprietary rights I was legitimately claiming. Typically, in cases like yours, a fair percentage would be between 20 and 30% of the total value recovered through judicial sentence or extrajudicial agreement negotiated before formal conclusion of the process, which means you wouldn't need to disburse substantial attorney fees up front. I would share Chisel but would share part of recovered values with the lawyer who invested time and professional expertise necessary to obtain judicial recognition of your historical financial contributions. The contingency-based compensation model Dr. Fernando proposed was attractive because it eliminated the need to disburse substantial attorney fees up front when my finances were extremely limited, although it obviously meant that a portion of values eventually recovered would be destined to compensate the lawyer instead of reverting entirely to me as restitution for the monumental sacrifices I had made during 15 years financing property I now discovered was registered exclusively in Patricia's name. This contingency-based fee structure seems reasonable considering my current financial limitations, although obviously I would prefer to keep the entirety of recovered values considering they represent restitution for 15 entire years of brutal financial sacrifices. I responded honestly expressing ambivalence about sharing recovered values, but pragmatically recognizing that structure could be the only viable way to seek legal justice without completely compromising already precarious financial stability. I perfectly understand your perspective, Ms. Marina, and I want to emphasize that the percentage destined to attorney fees would be calculated only on values effectively recovered through judicial sentence or agreement. Idea rate tanks heuristic, which means if litigation didn't result in substantial recovery, you wouldn't be financially worse than you currently are beyond basic court costs that unfortunately are inevitable in any legal process. Dr. Fernando clarified, revealing that financial risk would be limited primarily to court costs, that although substantial would be significantly less than fixed attorney fees that would normally be charged up front during prolonged procedural processing. Additionally, there are legal mechanisms like fee waiver that can be requested for people with limited financial resources, which could partially or totally exempt you from court costs depending on evaluation that the court will make. About your current financial capacity considering salary as a nurse and especially absence of accumulated estate due to sacrifices you made during 15 years transferring most of your salary to finance someone else's property. The mention about possibility of requesting fee waiver brought additional hope that litigation could be financially viable even with extremely limited resources characterizing my current situation after a decade and a half sacrificing prospects of building personal financial stability. The fee waiver request would be based on detailed declaration about your current financial situation, including monthly salary, basic expenses like rent and food, absence of accumulated estate, and especially history of financial sacrifices during 15 years that left you without substantial savings that would normally be expected for someone consistently working during a decade and a half in a reasonably remunerated profession like nursing. Dr. Fernando elaborated, revealing that my precarious financial situation that would normally be a source of shame could actually be transformed into a legal argument to obtain exemption from court costs that would make litigation more financially viable. Combining contingency-based attorney fees with potential exemption from court costs through fee waiver, we can make litigation financially viable. First, even considering your current resource limitations, he summarized offering a pragmatic path to seek legal justice without completely compromising already precarious financial stability. However, I must also alert you about the fact that even with these facilitated financial structures, prolonged litigation will inevitably consume substantial emotional resources during years of procedural processing that will include multiple hearings, potentially confrontational depositions with your mother and your sister, and especially prolonged uncertainty about final outcome that cannot be guaranteed in advance, even with a legally solid case like yours. Eichwert Zarin I that possesses robust legal grounding but is still subject to judicial interpretations that can vary depending on particular perspectives of judges evaluating evidence presented by adverse parties. Dr. Fernando's renewed warnings about emotional costs of litigation were necessary because I needed to make an informed decision about proceeding with a judicial process, fully understanding not only financial costs, but especially psychological costs involved in years of legal battle against family members who had cruelly betrayed me, but with whom I had maintained close relationship for decades, before that devastating discovery completely transformed my understanding about the nature of those family bonds. Before we make a final decision about initiating formal litigation, I'd like to suggest an alternative that could potentially resolve the situation in a less adversarial and faster manner than prolonged judicial process. Dr. E. Fernando proposed introducing a possibility I hadn't previously considered during my obsessive ruminations about available courses of action. We could first try extrajudicial mediation where you, your mother, and your sister would meet with a neutral professional mediator to discuss the situation and potentially negotiate an agreement that would recognize your substantial financial contributions through equitable division of the property. For adequate financial compensation without need for prolonged and emotionally devastating litigation. The suggestion about extrajudicial mediation was simultaneously attractive for offering possibility of faster and less adversarial resolution, and concerning because it would require directly confronting Sandra and Patricia in a structured environment where I would need to explicitly articulate my claims before family members who would probably deny or minimize validity of my expectations about proprietary recognition based on financial contributions they directly witnessed, but apparently didn't consider created binding legal obligations. Extrajudicial mediation has substantial advantages over formal litigation, including potentially much faster resolution that could happen in a matter of months instead of years, significantly lower costs because it avoids prolonged expenses of judicial procedural processing, and especially possibility of preserving some residual family relationship that would be inevitably completely destroyed through prolonged adversarial litigation. Dr. Fernando explained, highlighting pragmatic benefits of trying mediation before escalating to formal judicial battle. However, I must also be honest about limitations of extrajudicial mediation. Arian, that fundamentally depends on good faith of all parties involved to productively negotiate aiming at mutually acceptable agreement. He warned tempering optimism about mediation with realism about challenges of negotiating with people who had already demonstrated willingness to systematically exploit me during 15 years through a financial arrangement built on implicit promises never intended to be adequately fulfilled. If your mother and your sister don't recognize legitimacy of your claims and refuse to negotiate equitable division of the property or adequate financial compensation during mediation, then we would inevitably need to escalate to formal judicial litigation. Saistak dashars where courts will authoritatively decide based on evidence and legal arguments presented by adverse parties instead of depending on voluntary consensus that characterizes successful mediation processes. Dr. Fernando's realistic description about limitations of extrajudicial mediation revealed that although that approach could potentially resolve the situation more quickly and less adversarially, its success would fundamentally depend on Sandra and Patricia recognizing validity of my claims and demonstrating willingness to negotiate equitably, instead of simply defending the exclusive transfer they had already formalized through official notarial documentation. By Tricabrow. Honestly, I have substantial doubts about whether my mother and my sister would be willing to productively negotiate during mediation, considering they deliberately formalized exclusive transfer of the property to Patricia immediately after completion of the last financing payment I entirely covered, which suggests strategic planning instead of simply oversight or misunderstanding about my expectations of proprietary recognition. I expressed justified skepticism about probability of mediation resulting in satisfactory agreement given Sandra's prior behavior that seemed to indicate deliberate exploitation instead of simple misunderstanding about nature of the financial arrangement between us. Shurikuri Kayak Dr. Fernando nodded understandingly, recognizing that my skepticism about viability of mediation was grounded in observable behavior of Sandra and Patricia that suggested deliberate intention to exclude me from proprietary recognition, despite monumental financial contributions that had made the property's acquisition possible. Your skepticism is completely justified considering the strategic timing of transfer to Patricia that occurred specifically after the last payment was completed, which really suggests deliberate planning instead of simply misunderstanding about your legitimate expectations. He agreed, validating my perception about the intentional nature of exploitation I had suffered. However, even recognizing low probability of mediation resulting in satisfactory agreement, it may still be strategically advantageous to try mediation first for various practical and legal reasons that would strengthen eventual judicial litigation if mediation failed, as we anticipate to be likely. Dr. Fernando's suggestion about trying mediation, even anticipating probable failure, seemed counterintuitive initially, but his following explanations would reveal strategic logic underlying that apparently paradoxical recommendation. First, courts frequently favorably evaluate parties who demonstrate good faith trying to resolve disputes through mediation before initiating formal litigation. Which means if we try mediation first and it fails due to Sandra and Patricia's intransigence, that will strengthen our narrative before judges that you're reasonably seeking legitimate recognition of your contributions while adverse parties are inflexibly refusing to equitably negotiate. He explained, revealing how a failed mediation attempt could be transformed into strategic advantage during subsequent litigation. Second, mediation will allow us to directly observe arguments and strategies that Sandra and Patricia will use to defend exclusive transfer, which will help us prepare more effective counter-arguments when we formally litigate before courts. The strategic logic Dr. Fernando articulated about benefits of trying mediation, even anticipating failure, was persuasive, because it transformed that good faith attempt into strategic investment that would strengthen subsequent legal position instead of simply futile negotiation exercise with people demonstrating systematic bad faith. Third, and perhaps most important, mediation will allow us to directly confront your mother about motivations and justifications for exclusive transfer. She formalized benefiting Patricia instead of recognizing your substantial contributions, which could potentially result in admissions or statements we could later use as evidence during formal litigation if mediation fails. As we anticipate, he continued, revealing how mediation could simultaneously function as genuine resolution attempt and as opportunity to collect additional evidence that would strengthen subsequent judicial case. People frequently make spontaneous statements during informal mediations that they wouldn't make in formal depositions before courts. So mediation offers us opportunity to potentially obtain valuable admissions about the financial arrangement and expectations that were created during those 15 years of substantial contributions. The strategic perspective Dr. Fernando offered about mediation as simultaneously good faith resolution attempt and evidence-gathering opportunity. Because Sazero was convincing, because it transformed that approach from potentially futile to strategically advantageous, regardless of whether it resulted in satisfactory agreement or not. Based on all these considerations, my professional recommendation would be to first try extrajudicial mediation through formal letter. We would send to your mother and your sister proposing meeting with neutral professional mediator to discuss equitable division of the property or adequate financial compensation, recognizing your substantial contributions during 15 years of monthly payments that made the property's acquisition possible. Dr. Fernando proposed concrete course of action. That balanced genuine attempt at less adversarial resolution with strategic preparation for formal litigation if mediation failed, as we both anticipated to be likely given Sandra and Patricia's prior behavior. If mediation results in satisfactory agreement, we'll avoid years of emotionally devastating and financially costly litigation, while still obtaining recognition of your contributions through proprietary division or adequate compensation. And if mediation fails as we anticipate, we'll have substantially strengthened our legal position for subsequent litigation through demonstration of good faith and potential admissions obtained during mediation process. The Dr. Fernando's balanced recommendation about trying mediation first before escalating to formal litigation was sensible because it offered remote possibility of faster and less adversarial resolution while simultaneously strengthening strategic preparation for prolonged judicial battle that would probably be necessary given Sandra's prior behavior, demonstrating systematic bad faith instead of simple misunderstanding about my legitimate expectations of proprietary recognition. I agree that trying mediation first makes strategic sense, even recognizing low probability of resulting in satisfactory agreement, because it will demonstrate good faith on my part while potentially exposing their intransigence. That will strengthen subsequent judicial case, I responded, accepting Dr. Fernando's professional recommendation about strategic sequence of actions, beginning with less adversarial attempt before escalating to formal litigation. How long does it normally take to organize and complete mediation process before we know if we'll need to proceed with formal judicial litigation? Complete mediation process normally takes between 2 and 4 months from initial sending of formal proposal until conclusion of mediation sessions that will determine whether satisfactory agreement can be negotiated or if we'll inevitably need to proceed with judicial litigation, Dr. Fernando responded. Warren speaks providing realistic chronology that would allow me to adequately plan coming months, considering emotional and financial uncertainties associated with potentially confrontational negotiation process with family members who had cruelly betrayed me. We'll begin by sending formal letter to your mother and your sister proposing mediation and briefly explaining legal grounds of your claims over property based on substantial financial contributions during 15 years. And then we'll await their response that will indicate willingness or refusal to productively participate in mediation process, aiming at equitable resolution of the estate dispute. The description of the process revealed that first steps would be relatively simple, involving mainly formal communication, proposing mediation. But subsequent phase would fundamentally depend on how Sandra and Patricia responded to that proposal. If they accept to participate in mediation, we'll coordinate with neutral professional mediator to schedule initial sessions where each party will present their perspectives about the situation and especially about what they would consider equitable resolution of the dispute. Dr. Fernando continued describing mechanics of mediation process. I would need to adequately understand before committing to participate in that potentially confrontational procedure. The mediator won't make authoritative decisions like a judge would in formal litigation, but rather will facilitate productive dialogue between adverse parties, trying to identify possible agreement points, and especially propose creative solutions that could satisfy interests of everyone involved, instead of simply determining winner and loser, as would happen in formal judicial decision. The characterization of mediation as facilitated collaborative process instead of authoritative adversarial process was comforting because it suggested remote possibility of resolution that would preserve some residual family relationship, although my skepticism about Sandra and Patricia's good faith made it difficult to imagine scenario. Chances there are where that collaborative approach would result in truly equitable agreement. And if they simply refuse to participate in mediation or participate but demonstrate complete inflexibility, refusing any proprietary division or significant financial compensation, I asked anticipating the most probable scenario based on Sandra's prior behavior that demonstrated systematic exploitation, instead of willingness to legitimately recognize my substantial contributions. In that case, we'll have clearly demonstrated good faith on your part through genuine attempt to resolve dispute less adversarially. And then we'll immediately proceed with formal judicial litigation. Presenting detailed initial petition before competent court, requesting legal recognition of your contributions, and especially equitable division of the property, or adequate financial compensation that reflects value of contributions you made during 15 years. Literally sacrificing everything to finance acquisition of property, now registered exclusively in your sister's name, who never financially contributed. Dr. Fernando responded, confirming that mediation refusal or intransigence during negotiations would result in immediate escalation to formal judicial litigation, where courts would authoritatively decide based on evidence and legal arguments presented by adverse parties. The Miran Danigab, I left that law office approximately 2 hours after entering, carrying simultaneously crushing weight of difficult decisions I would need to make about how to proceed against Sandra and Patricia, and renewed hope that perhaps there existed a viable path to seek legal recognition of my contributions through a legal system theoretically designed to resolve complex estate disputes, protecting rights of people who had been systematically exploited by manipulative family members. During weeks following that initial consultation with Dr. Fernando, I obsessively dedicated myself to compiling documentation necessary to ground eventual judicial process or extrajudicial mediation. Requesting complete banking statements covering 15 entire years of monthly transfers. Reconstructing detailed chronologies of significant conversations with Sandra that could establish legitimate expectations of proprietary recognition, and especially cautiously contacting Gabriela and Marcos, requesting they consider providing testimonies confirming knowledge they possessed about exploitative financial arrangement that had consumed my life during a decade and a half. Gabriela immediately responded with enthusiastic support, readily offering to testify about conversations she had directly witnessed between me and Sandra during visits to my tiny apartment. Where she observed systematic pattern of substantial monthly transfers destined to finance someone else's property, while I lived precariously in inadequate housing conditions that grotesquely contrasted with the comfort my mother enjoyed. Marina, I always thought it absolutely unfair how your mother financially exploited you while your sister lived comfortably without contributing anything to family support. and I'm horrified but not surprised to discover she registered the property exclusively in Patricia's name after you entirely financed it for 15 years. Gabriella declared with genuine indignation that validated my perception about the exploitative nature of the arrangement. I had naively tolerated during a decade and a half. I'll absolutely do everything I can to help you seek justice through detailed testimony about everything I witnessed during years visiting you and observing monumental sacrifices you made, transferring most of your salary to finance someone else's house, while living precariously in an inadequate tiny apartment. Marcos responded more cautiously, reflecting emotional complications of our relationship that ended bitterly but eventually agreed to provide limited testimony confirming knowledge he possessed about the financial arrangement, and especially about how that arrangement had negatively impacted our prospects. Of building a shared life when we were engaged planning a marriage we eventually canceled, due partially to tensions created by my inflexible family financial obligations. Marina, you know I always believed your mother was exploiting you and that your sister should contribute proportionally instead of letting you carry the burden alone, he wrote in a carefully formulated message that acknowledged the position he had always maintained during our relationship. Although our relationship ended and I've moved on with my life, I still fundamentally believe you deserve recognition for the monumental contributions you made during 15 years. So I'm willing to testify limitedly about knowledge I possess about the financial arrangement if that helps you seek the justice you legitimately deserve. Approximately 6 weeks after that initial consultation with Dr. Fernando, he finally sent formal letter to Sandra and Patricia proposing extrajudicial mediation and succinctly explaining legal grounds of my claims over property based on documented financial contributions during 15 years that had made the property's acquisition possible through sacrifices they directly witnessed but apparently didn't consider created binding proprietary obligations. And the letter was simultaneously formal in precise legal language and compassionate in tone, recognizing emotional complexities of family disputes over recognition of historical financial contributions. I anxiously awaited during the following 2 weeks, expecting response that would indicate whether Sandra and Patricia would be willing to productively participate in mediation, or if they would simply refuse negotiation, confirming need to immediately escalate to formal judicial litigation where courts would authoritatively decide about equitable division of the disputed property. The response when it finally arrived was devastatingly predictable, confirming my worst fears. About Sandra's systematic bad faith instead of simple misunderstanding about my legitimate expectations of proprietary recognition. Through a lawyer she had quickly hired after receiving our mediation proposal, Sandra inflexibly rejected any claim I might have over the property, arguing that monthly transfers I made during 15 years constituted voluntary gifts made by dedicated daughters supporting maternal housing needs without any formal expectation of proprietary recognition, and especially that she possessed absolute legal right to distribute her estate as she desired, including exclusive transfer to Patricia, that had been appropriately formalized through official notarial documentation. The response even included veiled threats to sue for defamation if I continued publicly alleging I had been systematically financially exploited, revealing Sandra's willingness to not only deny recognition of my contributions but also to legally intimidate me should I persist seeking justice through courts. When I showed that devastating response to Dr. Heir, Fernando during emergency meeting requested immediately after receiving letter from Sandra's lawyer, he carefully read the entire document before commenting with mixture of professional frustration about adverse parties' intransigence and renewed determination to seek justice through formal litigation that now became inevitable. Your mother's response confirms exactly what we anticipated. Inflexible refusal to recognize legitimacy of your claims, an attempt to characterize monumental contributions as voluntary gifts instead of financial investments that created legitimate proprietary rights. He observed with tone mixing disappointment about mediation failure we both had anticipated but hoped to avoid, and strategic satisfaction that we had fulfilled obligation to try less adversarial resolution, demonstrating good faith that would strengthen subsequent legal position. The veiled threats about suing for defamation are common intimidation tactics in family disputes. But don't possess substantial legal grounding, considering you're simply alleging verifiable facts about documented financial contributions that can be proven through banking statements we've already systematically compiled. Now that mediation attempt failed completely due to Sandra's intransigence, who inflexibly refused any productive negotiation. Will immediately proceed with formal judicial litigation, presenting detailed initial petition requesting legal recognition of your contributions, and especially equitable division of the property or adequate financial compensation that reflects real value of contributions you made during 15 years entirely financing acquisition of property. are now registered exclusively in your sister's name, Dr. Fernando declared with renewed professional determination, transforming frustration about mediation failure into energy directed toward meticulous preparation of formal litigation that would consume coming years, but offered real possibility of judicial recognition of my contributions through legal system, theoretically designed to protect rights of people systematically exploited by manipulative family members. During the following 3 months, Dr. Fernando worked tirelessly preparing extraordinarily detailed initial petition that systematically presented all legal arguments grounding my claims over property. Compiled documentary evidence including complete banking statements demonstrating consistent pattern of substantial monthly transfers during 15 years, and especially organized testimonies from Gabriela and Marcos confirming knowledge they possessed about exploitative financial arrangement that had consumed my life during a decade and a half. The initial petition, when finally formally presented before competent court, was an impressive 147-page document that transformed my painful personal experience into structured legal case, solidly grounded in principles of unjust enrichment and recognition of historical financial contributions that American courts consistently recognized as legitimate bases for restitution of improperly transferred resources. Months transformed into years, while judicial process slowly advanced through multiple instances, including initial phase of contestation presentation by Sandra and Patricia's lawyers, who predictably argued my transfers had been voluntary gifts, probationary phase where testimonies were formally collected, and documentary evidence was meticulously examined by judicial experts. And finally, multiple hearings where arguments were orally presented before judges evaluating credibility of conflicting narratives presented by adverse parties. An emotionally charged estate dispute that had completely fragmented our family. The judicial process was exactly as emotionally devastating as Dr. Fernando had warned during initial consultation, including particularly painful moments during hearings, where Sandra coldly testified that I had voluntarily contributed without any expectation of proprietary recognition, and especially that she possessed absolute right to distribute her estate as she desired without obligation to recognize contributions she characterized as normal filial support, instead of financial investments creating legitimate proprietary rights. Patricia similarly testified that she had no knowledge of any expectation I maintained about proprietary recognition, and that she had accepted the property as legitimate gift from mother who had legal right to make that exclusive transfer through appropriate notarial documentation. Their testimonies were strategically coordinated by experienced lawyers who had meticulously prepared consistent narrative, minimizing magnitude of my contributions, and especially characterizing arrangement as normal family support instead of systematic exploitation that courts should remedy through equitable division or adequate compensation. However, testimonies from Gabriela and Marcos were extraordinarily effective. In countering narrative presented by Sandra and Patricia, with Gabriela emotionally describing monumental sacrifices she had witnessed during years visiting my tiny apartment, and especially telephone conversations she had witnessed where Sandra expressed gratitude for contributions and made implicit promises about future recognition that reasonably induced my legitimate expectations of proprietary rights. Marcos similarly testified about knowledge he possessed about the financial arrangement, and especially about how that arrangement had devastatingly impacted our prospects of building a shared life when we were engaged, confirming that in his perception as close third-party observer. I was clearly making financial investments destined to acquire property instead of simply making voluntary gifts without expectations of formal proprietary recognition. After 3.5 years of prolonged litigation, including multiple appeals presented by both parties trying to postpone or accelerate final resolution depending on how intermediate decisions favored respective interests, court finally rendered definitive sentence partially recognizing my financial contributions and determining I possess legitimate rights over 60% of the disputed property, reflecting magnitude of documented contributions during 15 years. Puyi that had made acquisition possible through sacrifices courts recognized created binding proprietary obligations instead of simply constituting voluntary gifts as Sandra and Patricia had inflexibly argued. The sentence determined property should be sold through judicial auction, with 60% of resulting values destined to me as compensation for historical contributions, and 40% distributed between Sandra and Patricia, reflecting original ownership registered in Sandra's name before contested transfer to Patricia. Although that sentence didn't fully recognize my contributions that had effectively financed 100% of the acquisition, it represented substantial victory that validated years of sacrifices and especially established legal precedent that substantial family financial contributions create binding proprietary rights that cannot simply be ignored through exclusive transfers formalized after contributions are completed. Values recovered through judicial sale of the property finally allowed acquiring modest, but comfortable apartment of my own, that represented first truly my own home after decades living precariously in inadequate rented property, and especially provided financial security I had sacrificed during 15 years financing someone else's housing stability, who never intended to adequately recognize my monumental contributions. Our relationship with Sandra and Patricia was irreparably destroyed through years of adversarial litigation that publicly exposed dysfunctional family dynamics characterized by systematic exploitation and arbitrary favoritism. But that loss of family bonds that were already fundamentally compromised by original betrayal was the price I accepted paying to seek legal justice that would finally recognize decades of sacrifices that had been systematically denied through financial arrangement built on implicit promises never intended to be adequately fulfilled. Heir, did you enjoy Marina's story? Then subscribe to the channel, leave your like and comment where you're watching from. Oh, and there's another story waiting for you here on the screen. Click there because I'll be waiting for you.